Now, you must have noticed that in the last 1.5 to 2 years, there is lot more awareness of mediation, lot more curiosity about what mediation is about. And if not the SCM, chiefly because of the SCM, we can say that this has come about. The SCM has given credibility and legitimacy to the mediation process for the first time as an ADR method. And because of this recognition, there is spread of the concept of mediation and awareness across the world. This treaty was signed in August of 2019, and it was put in force from September of 2020. There were 52 nations that signed this historic treaty. Initially known as the United Nations Convention on Settlement of Disputes through Mediation, this is also informally called the Singapore Convention on Mediation. This is because this treaty was signed in Singapore. Now, coming to the scope of this treaty deals only with cross-border disputes and with international law. Why then is it that this treaty and this convention is so important and considered so significant in the mediation community and in the history of mediation? This is because for the first time, as already mentioned, mediation has been given an equal stature as to other methods like arbitration and court judgments and so on. So it is an expectation that, like in the Singapore Convention, which has paved the pathway for cross-border disputes and international law, in time, it is expected that mediation will be the in thing even in the domestic scenario and in domestic disputes. Now, the format for today's talk will be what is it that set the background or the backdrop for this treaty. Secondly, we will be looking at the history preceding the SCM, which is how I will be speaking about the Singapore Convention on Mediation. And the third part will be on the scope and terms of the SCM. Last but not the least will be the distinguishing features of the SCM. Now, coming to the background, given that we had so many other ADR methods and other methods like courts, judgments, and so on, where was the need for a need felt or expressed need for a method like mediation? For this, there was a study conducted by the Singapore International Dispute Resolution Academy, wherein 304 respondents across the world were interviewed and surveyed. So in this study, the respondents were asked, why is it that they chose a particular ADR method? The respondents stated that they were looking for an expedited enforcement mechanism, and it is in this that the SCM stands out, in that unlike the other methods like arbitration and such others, SCM ensures enforced settlement agreements and expedited enforcement of the settlement agreements. The settlement agreements are enforceable, something that is not provided for in the arbitral context. Now, coming to the cross-border disputes, the parties stated that they expected greater compliance in the case of disputes that were settled through mediation, and they were also willing to take a risk in case of non-compliance of the settlements. They were also willing to take the risk in case of not reaching a settlement through mediation. That is, there were three issues here. Firstly, they were willing to take risk in case of non-compliance of the settled disputes. They were willing to take risk in case of non-settlement of the disputes, and they expected compliance of the settlement by mediation. Another study that was conducted in the year 2014, the Convention on Shaping of Dispute Resolution for the Future. Now, in this convention, there were 150 delegates from 25 countries across the world. They were business entities who were accompanied by business councils. That is, they knew the company business. Now, on being asked, the business community delegates wanted the arbitrators to advise them on another method for resolving their disputes, which would assure them of quality of outcomes. They were looking for quality in the outcomes and building of relationships, which was very important for them as a business community. Now, 2/3 of the delegates also stated that they would like to have a cooling off period before a full-fledged arbitration, and they also wanted greater amount of autonomy vested in the parties to take the resolution process forward. So here again, we see that in all of these cases, the requirement is for the tenets of mediation, that is, building of relationships, looking for quality outcomes, and giving the autonomy to the parties in taking the dispute resolution forward, and the desire of the parties to they were looking for a method like mediation. So perhaps this was what set the stage for the Singapore Convention on Mediation. Now, looking at the history and progress of alternate dispute resolution methods, firstly, there was the New York Convention, which was held in 1958. And this was significant in that for the first time, arbitration was given legitimacy as an ADR method. And the primary objective of this convention was to give recognition to the arbitral awards as being legally binding in cross-border disputes. So this is what was the objective of the New York Convention. Now, as a result of this New York Convention, it was found that there was increase in international trade. It was found that the number of disputes came down, and also there was greater harmonization and unification across the world. We'll have a brief overview of what harmonization and unification means shortly. After the New York Convention, there was the United Nations Commission on International Trade Law, which was adopted in 1966 as a subsidiary body of the General Assembly of the United Nations. Here again, the focus was on harmonization and unification. Now, what does harmonization mean? Harmonization is an effort to ensure that different legal systems generate similar transactions across different legal jurisdictions. That is, the impact is similar across different legal systems and jurisdictions. Now, in the case of unification, you go one step further. In the case of unification, the existing laws of a state are repealed and new laws are put in place in order to bring about a unified version across nations. This is the concept of unification. So with the arbitral and the unification and harmonization process, there was still further increase in the international trade. There was improvement in communication between the peoples. There was more communication across peoples in nations. And last but there was more peace as a result of all that. Last but not least, it gave a voice to the people and nations from the developing nations. And for the first time, the arbitral, it put in place conventions, it framed rules and laws in order to assist the people from developing nations to as equalizers. These laws and rules served as equalizers, giving opportunities to people in the developing countries. So this is what the arbitral did. Now, after this came the Singapore Convention, the International Mediated Settlement Agreement here. International Mediated Settlement Agreement, IMSA, which is an extremely powerful statute and legal instrument which was put in place, which is a legal instrument that is given equal power as to an arbitral award, to a court judgment. Therefore, for the first time in the field of mediation, we had an instrument, the IMSA, with equal stature, equal legitimacy and stature as other methods of dispute resolution. So this set the stage for the SCM, and putting in place of this IMSA was done by 90 experts across the world for 3 years. So this IMSA was put in place in December of 2018, and subsequently the Singapore Convention on Mediation was put in place in August of 2019. We will go through the enforcing power of international mediated settlement agreement in detail to understand how important it is in the field of mediation. Now, coming to the scope and terms of the SCM, it applies only to international law and to cross-border disputes. It doesn't apply to family disputes, domestic disputes, employment, or consumer inheritance, and so on, as already stated. The settlement agreements, as per in the purview of the SCM, should not have been recorded or enforceable as arbitral awards or as court judgments. They should have been, the settlement agreements should have been approved by a court or concluded during proceedings before a court. So this is the scope and terms of the SCM. I will go through the distinguishing features of the SCM first, and maybe later I will go through what is meant by the term international. Now, coming to the distinguishing features of the SCM, the first is that the dispute resolution process has to be through mediation to qualify under the SCM. Secondly, there should be evidence that the the agreement that came to be is a result of mediation. First is there should be, the process should be through mediation. The second is there should be an evidence. Now, the SCM also provides for the settlement agreements to be in writing and online. So the concept or the clause of online has great significance in that in writing includes electronic communication, which can be emails, SMS, online communication, which is not normally the case in the case of arbitration or court judgments. Now, any form of electronic recording which is retrievable at a future point in time or when we require this information comes under the in writing clause. Secondly, it is under the purview of the SCM that the resolution process can be done it need not be done at one go, it can be ad hoc, and there is no requirement for a single document in the case of the settlement reached through SCM. Thirdly, the mediation can be institutionalized through remote platforms having their own set of rules and with a panel of mediators. Now, all of these are issues or concerns which have been taken care of with the onset of COVID. These are the facilities that we are using in the COVID during the COVID phase from March 2020, and with the provisions of the SCM covering the in writing, the communication through electronic information, communication methods, institutionalized platforms, the dispute resolution has become easier during the time of COVID because of the SCM that was put in place in August of 2019. Now, coming to the IMSA or International Mediated Settlement Agreement, it is an extremely powerful statute in that it is enforceable, it is predictable. How is it that this enforcement process can be done? For this, the signatory countries can change the laws on recognition and enforcement of the DR outcomes. They can expand the nature and number of legal instruments that can be used under private international law, and the signatories and other agencies can also modify their laws in private and court procedures for the purpose. Now, the International Mediated Settlement Agreement is powerful in the sense it can be used as a sword against a sword, against a dishonoring party if it dishonors its end of the bargain. This can be done by attaching or seizing the assets of the other signatory party to the extent that the dishonor has taken place. So by this, what is assured and the parties are compelled to honor their part of the bargain. Both the parties are compelled to honor their part of the bargain. So with this cutting-edge power of the International Mediated Settlement Agreement, this is something that is not prevalent in arbitration, court judgment, or any other method. This is why mediation gets an edge over any other method, that ADR method, and that is why it is so significant. In this context, there is a study by PricewaterhouseCoopers in the year 2008, wherein it party stated that they had come to a stage wherein they had resolved the issues themselves much before the arbitral award or decree was announced. So, keeping the process of mediation and the control of resolving the issue that is vested in the parties in the process of mediation, perhaps if the parties got to resolve the issues through mediation, the resolution process would be that much faster and there would be that much less number of unresolved disputes. So this is again an implication of how important the international mediated settlement agreement can be, and how much of scope the mediation process gives for resolving of disputes to the parties. Now, coming to the issue of flexibility. Now, mediation under the SCM also, it provides for flexibility in that issues that have not triggered or started the dispute process can be discussed. The issues, the conflicts, the perspectives, the solutions, all of them can be expanded under the SCM because of the provision for flexibility. The provision for flexibility allows for expansion of the terms of the mediation agreement. It allows for expanding the pie, something that is not provided for in other methods like arbitration or court judgments, which only allow for issues that have triggered or started the resolution dispute process to come to the fore. Now, there is no restriction on the pathways to entry into the mediation process. It could be through mediation clauses, it could be through court information sessions, and voluntary and mandatory referrals by courts. The voluntary referrals could be one-sided. That is, one of the parties could be opting for mediation, or it is also possible that both the parties would opt for mediation and ask for mediation in the court. And sometimes the courts also can refer mediation. In such a case, external mediators can be called for assisting in mediation, or internal mediators are also sometimes taken for mediation. Sometimes there are referrals by other competent authorities. Like, for instance, we have the European Directive of Mediation, which refers to the disputing parties the process of mediation. And then there are cost sanctions in certain countries, wherein in case mediation is not the pathway that is taken, cost sanctions are levied. Singapore, Hong Kong, Australia, these are some of the countries where these cost sanctions are levied. Now, delocalization was one of the chief selling points or significant factors of the SCM at the point when it was put in place. This was before the COVID started and online ADR started. The reason for this was that the SCM does not mandate that the mediation process take place in a particular place. It does not mandate that the settlement that happens be in a particular place. Therefore, it answers the tenets of mediation, that is, the parties can decide in a place at a time at their convenience about what they will discuss on the mediation platform and how they will resolve the dispute and how they will communicate. So this is what was meant by the delocalization, that is, no mandated place either for the resolution process or coming to an agreement. Now, coming to the onset of COVID last year, with the online dispute resolution process, what has happened is the delocalization, which is described in the SCM, it has the issues of not required to take place in a particular place, settlement not required in a particular place. These issues are not relevant anymore. However, there are certain issues which we can just go through. That is, the enforcement in the country of choice of the enforcing party is allowed as per the SCM. And the parties are allowed to design their solutions, and they are not restricted to a particular legal system. So this kind of brings internationality to the procedures, and the parties are not required to enforce the international mediated settlement agreement in a place where it was concluded. Now, with online methods, of course, this is being concluded online and the implications are different. Now, in order to honor this, what was done was it was not required to comply with domestic law requirements of the originating state. This was the meaning of delocalization. Now, today's session is chiefly for all of us to be aware of the SCM as a treaty, historic treaty, after the historic introduction of mediation, which was done by Professor Sanders in the last century. This is the next most important and significant treaty which all of us as mediators need to know about. And also sometimes even today, when I go out and I introduce myself as a mediator doing mediation, people ask me whether I am into meditation and if I'm a yoga trainer. So there is a requirement for all of us as mediators and mediation professionals to create awareness of the strengths of mediation as vis-a-vis other ADR methods. So today my talk with reference to SCM was to bring out and highlight the strengths of mediation vis-a-vis other methods, and just an idea about how to get across to people about the benefits of mediation, what is it that we as mediators do, and about the services that we render. Now, in this context, there is a requirement from all of us, other than just the SCM, There is a need for all of us for the sustenance of the mediation process and the wave of methods to spread across the world, to have an ecosystem of mediators, students, lawyers, litigants, all of us with awareness of mediation. There is a need to promote conversations on mediation. Last week, I was attending an e-mediation writing conference here, and I came across one of the chief speakers mentioning that it would be very difficult to take mediation to the people in that particular jurisdiction because people were not aware that something like mediation existed. They would only be going to the courts and to the lawyers in order to have their disputes resolved. Therefore, although the event was the opening of the e-mediation writings, the conversation was by one of the chief speakers the comment was about this. So there is a requirement by all of us to promote conversations on mediation. We need to tell people that this is a structured method like other methods. And the state courts have to actively promote and incentivize mediation. Like for instance, in other methods, the arbitrators, court judges, there are the certain amount of fee. So in order to incentivize in certain forums, it has been voiced that mediators need to be given a fee as well. I don't know how this will be handled or how this will be taken up or anything, but this is just an idea. And the federal, local, global, and other agencies need to put in place laws similar to the SCM in order to bring about enforcement of mediation, and greater coordination is required amongst agencies that facilitate mediation. For instance, many a time I have found that there is sometimes tech support lacking or some issues across the world. Sometimes these can hamper the process of mediation, and this is only an example. Tech support is only an example. There can be in many other coordinating factors to facilitate better mediation, and early intervention is also required in order to facilitate mediation. And with this, thank you all for your patient hearing, and namaste.